Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back to the now again filed challenge to California's magazine ban in the matter of Duncan v. Bonta. It is amicus week. That's right. If you want to be an amicus party to this, you need to get your briefs in. Turnout's been a little slow lately. I'm a little disappointed, but the brief that I'm going to talk about today, I really enjoyed reading it, and it brings a perspective to this discussion that we don't often get to talk about here at Washington Gun Law for various reasons, but it's one that we really need to understand because it goes really to the heart of the entire Second Amendment. So today, let's go through the brief and let's talk about the brief that proves the Second Amendment is for everyone. Okay, America, we are talking about challenges to magazine bans. There are two separate ones sitting before the United States Supreme Court. The one we're talking about today is the matter of Duncan v. Bonta. It is the granddaddy of them all. It's been going on since long before we had a YouTube channel, and it sits again on the doorsteps of the United States Supreme Court. There's another matter out of Washington, state of Washington versus Gators Guns, that I will clearly say right now, at best, is on the silver medal platform. Now, we're going to focus on a new amicus brief that has been filed, and I want you to know that the organizations responsible for this amicus brief include National African American Gun Association, Inc., Asian Pacific American Gun Owners Association, Chris Chang, DC Project Foundation, Inc., Operation Blazing Sword, Inc., and Gabriela Franco, and the Liberal Gun Club. And what I like about this memorandum is, yes, it does bring an extra perspective. We're going to link it all up down below. I want you to see where each one of these groups come from because they make very compelling arguments about why they shouldn't be limited in the number of rounds they get to carry for self-defense. But the 2 points that I think this brief really makes is, number one, this different perspective is great because it proves that the Second Amendment is in fact for everyone. The second thing it proves is that no matter how you see the world, no matter what your political slant is, no matter what your sexual identity is, no matter what your ethnicity is, it's easy to realize that the Ninth Circuit sucks. In the body of the memorandum, the amicus parties point out just how bad the Ninth Circuit got it. They plead the following. The Ninth Circuit's upholding of California's retrospective and confiscatory laws distorts this court's precedents and illustrates a disturbing and persistent trend where lower courts continue to sanction laws that erode the rights of American citizens. This court must intervene and establish clear and unequivocal guidelines for lower courts to follow in such cases to prevent the continued attempts to eviscerate the Second Amendment. And this is a disturbing trend. It is a trend that may have developed in the Ninth Circuit, but we have now seen it spread like wildfire. It has infiltrated the Seventh Circuit. It's infiltrated the First Circuit. It's infiltrated the Second Circuit. It's infiltrated the Fourth Circuit. So things from a health standpoint are not real good when you take a look at how these lower circuit courts are analyzing the Second Amendment. And even though it appears that the Supreme Court has provided clear guidance, it's not clear enough for many of these judges. The amicus party correctly points out, the analysis applied by the Ninth Circuit in this case at best distorts and at worst completely ignores this court's recent precedent. Instead of undertaking a clear textual analysis, the Ninth Circuit first took it upon itself to determine that magazines that hold more than 10 rounds are not arms and therefore do not even implicate the Second Amendment. The myriad reasons that this determination and line of analysis are improper and incorrect are thoroughly and capably elucidated in the petition, which the amici echo, but will not burden this court by repeating here. And again, whether they are saying more appropriate for military use or in common use for self-defense, they have literally bastardized all of the rules of law. But they have, in doing so, injected back into the legal equation balancing test, which Bruin was meant to remove from the equations forever. As the amici party points out, the Ninth Circuit undertook an analysis of how heavily California statutes burden Second Amendment rights, considering that burden to be minimal because firing more than 10 rounds occurs only rarely, if ever, in armed self-defense. These analytical schemes were plainly rejected by this court in Bruin. But you see, unless the United States Supreme Court actually grows a backbone and puts a stop to this insanity, or what we've called a Second Amendment mutiny upon the highest court in the land, This is not only going to persist, it will get crazier and crazier. With each opinion, we will come up with more creative ways to uphold these otherwise unconstitutional bans. That is not lost on the amici party as well. That lower courts persist with such warped and strange interpretation of this court's decision in Bruin makes plain why this court must provide further clarity and guidance. Citizens of California and other states with similar statutes, particularly those represented by the amici and other similarly situated individuals, must not have their Second Amendment right to determine what ammunition capacity is appropriate to protect themselves be dependent upon how many rounds of ammunition the government thinks is truly necessary. That decision is for the citizens to make for themselves. That is absolutely 110% correct. Kudos. I could not have said it better. Now, the other thing I like about this memorandum is they're like, hey, listen, California's statute bans possession of these as well, which means that all of us are going to be dispossessed of property because it's going to be illegal contraband, and yet the government is offering us no compensation. Is that a problem? Yeah, you bet it's a problem. It's a problem because it's a violation of the Fifth Amendment against unconstitutional takings. And the amici party correctly points out, in this case, the limitations on magazine capacity imposed by the California statutes is a de facto taking by the government. The takings clause provides that private property shall not be taken for public use without just compensation. Okay, listen, we're going to go ahead and link up the amicus brief below. I really do encourage you to take a look at how they introduce the parties and take a look at some of the plights of these particular demographic groups and why really government should not be dictating to these groups how valuable their lives are and how they get to defend it. The case once again is Duncan v. Bonta. We're going to link up the amicus brief down below so that you don't have to take our word for it. You can geek out on it for yourself. Now, kudos once again to all the amicus parties here, which include the National African American Gun Association, Inc., Asian Pacific American Gun Owners Association, Chris Chang, DC Project Foundation, Inc., Operation Blazing Sword, Inc., Gabriela Franco, and the Liberal Gun Club. If you guys got any other questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do that is all spelled out down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.
Therein lies why we say in the legal defense sector that we are the most value-centered, cost-effective legal defense in the space, and we are. There's no question. Now, again, I've said before, we've got great competitors out there. They have outstanding products. We admire them. They pave the way for us. You know, we analyze the folks out there that are doing the same thing we're doing, and we took some great ideas from them, and we went down a path of believing that we were going to do it with a service aspect, a servant's heart, and we have again. Our number one goal has been to serve others first in a way that the industry hasn't seen.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.